a center that has a training facility. Inside that facility is a mock courtroom. Inside that facility is a mock house or apartment where you could be training the lawyers, you can be training the law enforcement people, you can be training the caseworkers together to be going into a household and following a case all the way through as the week goes on. You go into the house with the trash strewn about and the parents there and begin the investigation. And as a team, throughout the week, you work through to the point where at the end of it, you're in front of the court, not just the prosecutors, but your children and youth solicitors who are prosecuting the cases before the court and having good quality prosecutions. I'd like to see Pennsylvania bring that model to here. They are looking, Victor Veith's group is looking for regional areas, regional training centers. There is one community college, I believe, in Arkansas that has signed up. I'd like to see Pennsylvania be the second regional training center in this nation. Once again, being at the beginning, not the end. If we can bring a regional training center here, you know, one of the things that makes it difficult for professionals, law enforcement, children and youth, and prosecutors to get this training is the cost. The cost. The biggest cost, airfare and hotel accommodations. The training themselves are usually reasonably priced. But if we bring something into the state, the Child First program, one of the things when the Children's Justice Act, and one of the groups that I'm involved with is I am co-chair of the Children's Justice Act, that task force. One of the things that we insisted with Child First was we wanted to have the money to provide for the travel and provide for the expenses of staying at a hotel for a week. That's what makes that program so great here. I don't know if we're going to be able to maintain that funding, but at least right now, for the next year and a half, we're offering that training free of charge to professionals. That's what we need. We need those professionals, those teams, to have those resources. Because if you're a small department in a rural area, it's going to bust your budget to go to some of these trainings. I know the solicitors are going to be taking Child First. They're going to be taking it on the circuit, going to different training areas. I believe they've partnered with the Pennsylvania State Police to use some of this Pennsylvania State Police regional training facilities. They're the type of ideas that we need to be pushing in order to properly train our professionals. And this is just a thing I've been thinking about for years when I drive in other states. We talk about funding all the time, and I wonder why in Pennsylvania we haven't been utilizing this. And what we would utilize it for, I'm not sure. Whether it be perhaps supporting training or perhaps supporting children's advocacy centers. Why don't we have license plates in Pennsylvania, child advocacy license plates? You drive into other states, you see the little handprints. You drive in our state, you see sports teams, you see all sorts of colleges, you see all sorts of groups that are getting money from license plates. It's a simple one. It's a simple one. I'd buy one of those license plates, and people might say, well, it's not going to be millions and millions of dollars. Okay, but it's going to be something. That's a simple one. Why don't we have license plates? And our child protection professionals can purchase them for, what, I don't know how much it is extra, $25 extra. There's an area to try to start raising money. So I appreciate, I'm monopolizing all the time here. I appreciate you listening to some of my rants and ravings, but I hope I've also, in addition of complaining, provided perhaps some ideas. Thank you.
Thank you very much. And it's those kinds of concrete ideas that I've been trying to think of, and you've served us up some good ones. I would note for the record that Mr. Veith will be presenting by way of, I think, closed circuit TV to, I guess, in the June meeting.
Good afternoon, Chairman Heckler and members of the panel. Thank you for having me. It's really an honor to testify before you. I feel like one of the folks down this end at the last presentation. Sean covered so much that some of the things I was going to say, so I kind of just get to the point. I've actually been in the DA's office this same amount of time as Sean. In 1989, I started in the Philadelphia District Attorney's Office. Probably about half of my career, in one sense or the other, has been spent in the homicide unit, and unfortunately, in many respects, became an expert on child homicide. Was involved in the investigation of the death of a young girl in 2006 in Philadelphia, a 14-year-old girl, Danielle Kelly, who died of neglect, horribly neglected inside of her home while she was under the auspices of the Department of Human Services. So we conducted a 2-year grand jury investigation of that case, arrested 9 people, including Child Protective Services workers. The whole case lasted about 5 years. And really, since that point, in August of 2006, came late to this field, but have been extremely interested and passionate about child abuse since that time. I think a couple of the things I would like to say here today, to echo what Sean said, one would be, we can't just depend on relationships that exist in jurisdictions to have things work out the right way. I think that's an excellent point that Sean made. In Philadelphia, things are certainly much better now in 2012 than they were in 2006. We just signed the interagency protocol, creating the team. It took about 10 years to do that. It finally got finished and is in existence now. So the interagency protocol is in effect in Philadelphia, but it took a really, really long time to do it, and in large part, I think, because of relationships that were built based on the new leadership teams in the DA's office and in the Department of Human Services, that was able to happen. And that's a good thing for the city, but it's not necessarily a good thing that it took so long for that to occur. And I think the other thing that I'd just like to touch on briefly would be the Act 33 process, which I think is extremely important, where all fatalities and near fatalities with an open or indicated CPS report are reviewed by, again, a multidisciplinary team. The Act 33 process in Philadelphia, I think, has been a tremendous benefit to the system. I was named to that team. Cindy's on that team right after the law was passed, and we were the first members, the first team. Many of us are still present in that, and I feel like that's a process that works very well. I think you may be able to use that as a model for other things that you're contemplating in terms of changes in the law. But a couple of things I think are very good about that process. One is that the reviews are done close in time to the incident. So you're not looking at something a year or a year and a half later. You're looking at something fresh. You're looking at something typically within a month of the incident occurring, which I think is an important thing. There's one thing I think I do want to talk about in terms of that, though. You talk about confidentiality laws. Now, obviously, those processes definitely need to remain confidential, but I think there could be some tweaks in the law in terms of what CPS providers are allowed to say. I think that the confidentiality law should be clarified in some respects so that they can release some additional information in certain cases. And I know Commissioner Ambrose testified before you and advocated for this, and I would reiterate that I think that she had stated that the release of information that could be deemed confidential in limited scenarios, including cases involving fatalities or near fatalities, where a child victim was in the custody of the county children and youth agency, had an open case with the agency, or where there had been a prior public disclosure of an investigation into the case of a near fatal or fatal child mistreatment. That's really a frustration I think that the public has a lot of times in these cases, is that they don't get the information, that they don't know exactly what occurred in a lot of times until much later in the process. I mean, Danielle Kelly died in August of 2006. Our grand jury report basically came out almost 2 years to the day later. So this child died, and for 2 years, some of the people that were working on her case remained employed in the Department of Human Services. That's a huge issue, I think, and so I support Commissioner Ambrose's call, and would ask you to seriously consider clarifications in that area, because I think it's really important for transparency's sake, and also to allow the public to have a little bit more confidence in what's going on there. And just one other thing I would like to touch on as well, and that would be an issue that's recently came to fore in our city. Another case I'm involved in, where a young boy, six-year-old boy, was found in his house, malnourished and basically beaten all over his body. There's many issues that came out of this case, but one issue that I think I would like to touch on, it may be deemed somewhat controversial, but I think it's important anyway, and I think that there should be some mechanism, process to ensure that children who are homeschooled receive some of the same protections and oversight in terms of child abuse prevention and detection as those who attend public, private, and parochial schools. And in this case, particularly if the homeschooled child's family has prior involvement with the CPS system. In fact, in this particular case, 2 of the children had been in placement, aged out of the system, and then 4 other children in the family, the parents voluntarily terminated their parental rights in the case. Yet this child was homeschooled, very little eyes on him in terms of, obviously, since he wasn't going to school. And I think it was kind of a gap that a lot of us in Philadelphia had discussed, that it may be a little bit of a gap, that's something that this task force can address. But again, I really much appreciate this opportunity to talk to you, and if you have any questions, I'll be happy to answer them. Thank you.
Thank you very much. The first shall be last, or vice versa. Ms. Hobbs-Pachado, your turn.
Okay. One of the things, and thank you for coming and presenting. One of the things that you brought up was really important about the homeschooling. I think I agree with you in reference to the homeschooling. Once a child has been brought to the attention of CYD or even with the criminal piece, that they should not go out of sight. No one can see what's going on with them. There are no eyes. There's no one. So I agree with you that they should be returned even to that home, if that is what deemed to be, that no homeschooling should be taking place at all. And that's not a law. So I was just wondering, is that possible? Is there some way that if a child is in that position or something of this nature has happened, that these children do not go out of sight?
Yeah, I mean, I think obviously homeschooling works for a lot of people. It's a really great option, but I think the point that I'm trying to make is that if someone has at least some prior issues with the child welfare system, that there's indicated reports, things of that nature, that there should be some sort of mechanism of some type of reporting that occurs, some type of oversight of the family, so that someone would have eyes on a child on a regular basis. I think that's really what I'm thinking that hopefully you guys will take a look at.
Yeah, I have to say, I find that, I hadn't thought of that myself, but I have a preliminary hearing tomorrow for a mother who was, after we arrested her husband for abusing her stepdaughter, very, very nasty sexual assault case. She withdrew her other children from school and began homeschooling them. We've now arrested her for endangerment and a bunch of other things, but it is certainly an issue that I don't see it very, very often, but it is one I've seen also out here.
Judge?
What are your thoughts about universal mandated reporter laws, similar to what I understand the state of Delaware has?
I'm not specifically familiar with that piece of legislation, so.
It's an all-encompassing law that basically makes everybody a mandated reporter. What are your thoughts about that?
Off the top of my head, I like it, but I haven't. I mean, people ask me all the time about being a mandated reporter, and we've got that big section that deals with mandated reporting, and then there's a real tiny section after it that tells people that, let me find that real quick here. people that are not required to report are allowed to report, and then they're given a certain amount of immunity for reporting if it's done in a good faith manner. So I'm always, somebody might say, well, I'm not a mandated reporter. I'm always encouraging people to report whether they're mandated or not. I guess I'd have to, being a lawyer, I'd have to look at, the specific language of everything, but I kind of like the idea.
Thanks.
Thanks. It was very, very informative. I appreciate the testimony today. Just a little piggyback on the last question. Chief McCormick, you said something about the penalties for people who, mandated reporters who do not report, rather creative. What about the other side? What about the ones that report knowingly false and perhaps maliciously? Do you have any thoughts on
I think they need to be charged. If the whole system starts to fall apart, if you're abusing the system, in fact, I think the system, to some degree, there's a large portion of the public that believe that it is being abused, whether it be a custody situation or I see occasionally our juvenile system, whether it be our detention center and those sorts of things, people saying that there is that the child's being abused, and it turns out that it was a false allegation. I think in those situations where you have a false allegation, to support the integrity of the system, you need to charge those people too. The one caveat to that is I think in all cases, whether it be the mandated reporter or the person that has falsified a report, I think you need to do a good, thorough investigation and to make a determination on a case-by-case basis.
It all comes back to a good investigation.
Yes.
Mm-hmm. Thanks.
Good afternoon.
Good afternoon.
Thank you both for your presentation and for the work that you do. I was a child abuse prosecutor for a few years, and I don't know how you've done it this long. It's mentally exhausting work.
That's why my hair's gray.
Mine is too. I just don't let other people know it. But I appreciate comments from both of you. I wanted to ask a couple of questions. Sean, in your experience, have you been able to utilize the CAC for physical abuse cases? There was some discussion of that earlier with the last panel. We have done some cases in Blair County more recently where the actual injuries are not evident on the child, and we believe there's probably a history of abuse, but it was only one incident that brought the child to the attention of law enforcement. And have you found that the CACs are helpful for sexual as well as physical abuse cases?
Yeah, we don't have a differentiation between
Okay.
child abuse is child abuse, whether it be physical abuse or sexual abuse. The child is the victim. So our policy is if the child is a victim of a crime or suspected abuse, we're going to bring them to our Children's Resource Center. And I would also add that we use our Children's Resource Center. I don't know if other CACs do similar things, but we have situations where a victim may be an adult but is mentally retarded or I'm not intellectually disabled. The terms are changing on me, but we'll have those people come through the Children's Resource Center using the same interview techniques and those sorts of things. So I think physical abuse, we'll take pictures of the physical injuries. We'll do the investigation the same way using a multidisciplinary team approach and all the way through. And our Children's Resource Center has a medical, it's based in a hospital, so we have that medical component. So definitely we use physical abuse cases as well as sexual abuse cases through there.
And I know that Blair County has utilized your Children's Advocacy Center or Resource Center for a few of the cases that we've handled. But your comments on the mandated reporting, would you envision a mandated reporting penalty section being in the crimes code then? Or are you just saying you would like the language change and you think it's okay to keep it in the CPS law?
For me, it's easier to find in the crimes code
Okay.
because that's what I look at all the time. And I'll give you an example. The Megan's Law.
Mm-hmm.
Megan's Law, once upon a time, had the penalty section within the Megan's Law statute, which is in Title 42. They moved it to Title
Crimes
18.
code.
to the crimes code. So I think if we're going to say it's a crime, let's move the penalty section to the crimes code so we can all find it nice and easy.
Okay. And Ed, with regard to the homeschooling, that has been one of the things that I think we should consider, so I appreciate you bringing that up. And I'm not as familiar with the Danielle Kelly facts, but as I understand what I do know about that case from reading it in the paper, that child also was homeschooled, correct?
She wasn't schooled at all.
Okay.
Unfortunately, that was a huge issue that went along with that case, that she had moved from Arizona to Philadelphia with her father and was never enrolled in a Philadelphia school. And there was one of the failings of the CPS system, that they knew this child was not in school, and it never happened where she got enrolled. There was testing going on, finally, probably within 2 or 3 months of Danielle's death, that was going to lead to her placement in school, but she had not been to school probably in about 4 or 5 years at the time of her death.
Now, I also agree that homeschooling is a wonderful option for some families, but do we, in Danielle's case, had she had prior involvement with CPS before she moved to Pennsylvania?
She had.
She had,
There was
okay.
multiple reports in Arizona and then in Philadelphia as well.
And the 6-year-old child that you referenced in your testimony, that child as well was homeschooled without any outside parties?
Correct.
Okay.
Correct.
Okay. Thank you very much.
Welcome.
Thank you, gentlemen. I ask a question of the previous panel. Do you know, are there any sentencing tools that would permit the courts to impose fines and costs that can be earmarked or targeted for child abuse or child abuse-related investigations or CACs or anything like that?
I would, I think Judge Grimm said it exactly right. I think that's a great goal, but I know in Philadelphia we're having problems collecting even for CVC. The CVC collections lag behind the rest of the state. There's a lot of fees have been imposed. I mean, the booking fee statute just came got passed a few years ago. There's the DUI costs. I mean, there's so much cost, and and as you've seen probably in news coverage, we're not that good of a city in terms of collecting a lot of that stuff. So I would just fear that something like that, I think, is a great idea to try to find a good funding stream for these types of entities, but that people would see that as a solution that really wouldn't bring in the money that would be needed.
Do you have suggestions on the homeschooling issue, on how to address those that have been involved, those whose children are in school age, whose parents had previous contact with CYS? What should we do about them if they want to homeschool? Should we bar them? Should we?
Well, you really put me on the spot. I don't know if I would necessarily say bar them, but I would say definitively if there be some way to have a regular monitoring. I don't know if they had to, if there's a way to have them bring their work to be monitored somewhere or something like that. In other words, just so there would be a way for the school system to have eyes on the child. That's really the important thing, I think.
And Sean, maybe you could, I'd like to talk a little bit about, and we've done this with previous days of testimony, the issues of the interplay between an indicated child abuse report and a founded. And as I understand, you started fairly recently, in the last couple of years, helping CYS over some of the hurdles that come from the department on whether or not the child abuse appeal on the indicated finding should end because jurisdiction is divested from DPW by way of your case, your criminal case. Can you talk a little bit about that interplay? I think you started doing some things to help alleviate, to make sure that the criminal conviction dovetails with the CYS investigation.
Yeah, I think, there's a few different things you can do. I mean, the first thing is communication from the beginning and kind of come up with a game plan. So even when you're filing charges or making a decision not to file charges, because sometimes the best thing that comes out of a multidisciplinary team is you discover maybe it is a physical abuse, maybe it's a young family, and do we really need to be putting them in a criminal justice system, or can we handle it through the child welfare system, or is there some other resource out there? They're the type of discussions we have at our case review meetings when we're trying to decide what to do. As a case moves on through the process, I know one thing in particular that I wasn't aware of, which was brought to my attention, Jason, from you, if you recall. We were occasionally allowing someone to sign up for the ARD program, the Accelerated Rehabilitative Disposition Program. Great. We had all the resources in place and all these great things. We thought that we had good results. Then I come to find out that on the child welfare system, since there's no conviction, they were appealing the finding of the child welfare system. So we made a condition of getting into the ARD program is that you will not appeal your child welfare finding, and we've been putting in that into our plea agreements also. So there's a lot of different ways that you can assist one another. The key is that you have to talk to one another. You have to know that issues are coming up. We had an issue recently where some of our I went and I became aware that there was someone advocating to lower bail for a parent who had been arrested, and because they wanted the condition of bail also to be changed so that the parent could have contact with the child. And I'm prosecuting the guy. The guy's facing a mandatory 5 to 10 years in prison. I'm not trying to encourage the two of them to get together. But once I found out about the situation, because we've built a strong relationship, I'm able to call the supervisors over at Children and Youth and say, hey, what's going on here? You know, you guys need to talk to me. I work very closely with the Child Protective Service workers, the ones who actually do the investigation. A lot of times I lose a little bit of what's going on in the child welfare system when it goes to the other side, as I call it, of the child welfare system. So we're trying to build those bridges on all sides so that there's a free flow of communication back and forth. If we can have that communication, I think that's where you become successful.
Good afternoon, gentlemen. Thank you both. Ed, congratulations on your MOU in the city of Philadelphia. I hope it works well. Sean, I have a couple of questions for you. First of all, in my experience, not every CPS report goes to law enforcement, right, historically, right? Child welfare would get lots of reports that wouldn't go to law enforcement. Are you advocating for all CPS reports to involve law enforcement?
If there's a suspected crime, yes, I am. And that really probably includes a significantly higher number than currently are. Because when you start talking about the endangering the welfare, that's where you start getting into the child neglect type cases. I mean, we had a case that, I mean, I hate to say it, but a nurse, who I don't even know her name, but confidentially called us to tell us one time that there were 2 twins, infant twins in the hospital that essentially were being starved by the mother because the mother was an alcoholic and wasn't mixing the formula properly and those sorts of things. And they were admitted to the hospital and their lives were endangered. But the interpretation on the child welfare side was that this was a child neglect type case and it was not one that should be given to law enforcement. Why not? We investigated it. We determined that there was a crime. There were a number of different things along the way, that steps that she should have been taking and those sorts of things, and we prosecuted her for that crime. So I do think that we do need to expand what is being shared, the information on both sides. If I'm saying that a professional is mandated to report to Childline suspected child abuse, why aren't we doing the same thing between law enforcement and the child welfare system? If one hand discovers something, why shouldn't they be reporting it to the other hand so that they can then jointly work on the case together? So I am.
I think that that's a little bit of a shift, because I think historically, not every case of child abuse that is even mandated and mandated reporters call in has been thought of in terms of the criminal justice system as well. I mean, I think clearly there are many of them that do go appropriately to criminal justice, but I think kind of if you say to a mandated reporter, let's just say a pediatrician, okay, call in what you think is suspected child abuse, in some cases that the response that they're looking for, or society might be looking for, is one where families can get assistance and help in the skills that are needed for parenting, as opposed to kind of looking at that case from kind of a criminal justice point of view. And I think that that's something that, like, we need to think about. And
I'm not advocating that every time a report's made that a crime needs to be charged, because I think the key is the communication as a team. I think it needs to be investigated. And once it is investigated, then the team needs to make a decision. If you have a good team, people that work together, if you have a good team working together, you should be able to reach a decision. Occasionally, and it's very rare, children and youth will disagree with us and will decide to file charges when they don't think we should. And there are times that they make a case unfounded where I'm like, I can't believe it's unfounded, and I'll file criminal charges and get a conviction on it. How could it have been unfounded? But that's very rare anymore. When we discuss cases, I find myself very often, and the police officers, and once you start working together, I like to use the term we co-op one another. You know, I don't like children and youth. Children and youth doesn't work with us, and children and youth doesn't like law enforcement. But once they start working together, you know, I hear the children and youth caseworkers suggesting criminal investigative techniques to the police officer, and those sorts of things. That when we start talking and then making decisions together, we just started our office along with our victim witness unit in Dauphin County just started an impact parenting program, because we were coming across so many cases that we were discussing a case review where it was just that situation. It was a family. Yes, it was abuse. Yes, I could file criminally. But is it the right decision to file criminally? Can we allow them to go through this parenting class and see how they do in that class, and then hopefully never see them again? That's a success, in my view, as a prosecutor. It's not about guilty verdicts and guilty pleas. It's about putting families in a position to succeed. That's what I think.
Okay. I have one other issue. Thank you. I appreciate that, and I agree with you. Okay, one other issue. So, you know, our society asks mandated reporters, and anybody really, to report suspected abuse, because we want to cast the net as wide as we possibly can, right? So that we identify as many of the children who are victims of abuse and neglect as we can. But that also means that in casting that net for mandated reporters fairly widely, we will inevitably kind of capture some children who are not victims of abuse or neglect. And one of my concerns is if we begin to penalize reporters who falsely report child abuse, that you will have situations, because we already have it, where when families have cases that are unfounded, either in dependency court or occasionally criminally, that they will go back and bring lawsuits, for example, against mandated reporters who are supposed to be reporting for false reporting. And so how do you balance, really, this asking society to report broadly, but then penalizing people for false reports, because false reports can be, in part, in the eyes of the beholder?
Well, I think there is some protection built into the Child Protective Services law using the language a good faith report. So I think you have to start there, that it was a good faith report, and if it's a good faith report, there should be some type of protection that is provided to the reporter. When it comes to a false report, that's already a crime. I don't even necessarily think we need to add any legislation to that. If you're falsely reporting a crime, it's already in the Crimes Code. I don't. It's not an easy question, because there are so many different scenarios, and when you look at some of the excuses why people don't report, you know, physicians sometimes don't report because they're afraid that what if they're making a mistake, and then the family doesn't trust them and leaves, and they're who's going to be taking care of this family? You know, I hear things about inadequate feedback, that the reporter makes a report and then they find out later on either it was unfounded or they don't find out anything. And there are reasons why sometimes people get disillusioned and they don't want to report anymore. And I think that some of that should go back to the training, the training piece. If we can get mandated reporters before they get into their occupations and then continue on with yearly training of mandated reporters, I think that helps. I don't know if I specifically answered your question, but I think...
We'll continue to deal with these issues. But thank you both very, very much.
Sure, there's one follow-up.
I'm just going to say real quick, that, as Sean said, false reports speaks of an intent. And that's, I think that's what we're talking about here. And we're talking about somebody, you know, who intentionally makes a false report. And there are already statutes on the books that deal with that. Not somebody that reports something that doesn't end up being correct or it ends up being unfounded. Them doing that in good faith is obviously not something that anybody would want to charge criminally.
Sean, would having the CYS solicitor, every county is required to have one, would requiring the CYS solicitor to personally sign off, kind of like the DA does on the information, sign off on the CY-48 before it's filed, would that make your job easier or make the communication flow better to help either your prosecution choices or decisions not to prosecute?
I don't know. I don't know the answer to that one. I know when it comes to criminal charges, it depends on county to county as to whether the DA has elected to personally review every one or not. Right. I know in Dauphin County, we have specific ones that need DA approval, but other charges, less serious charges, that don't. We kind of have an informal through our child abuse protocol that if you want to file criminal charges, you're going to bring them to our case review meetings, and we're going to make the decision there. And I pretty much chair those meetings, so most of the cases get run by me before the police file charges. It gives me an opportunity to see, as a prosecutor, what's going on by having me be an active participant. So I don't know if that's what you mean. Or...
I'm thinking of the example you said where CYS, you had a case, you thought there was great validity in bringing the charges in CYS maybe because of the time frame, they didn't have the evidence you ultimately got. But within their 60 days, they made a determination they need unfound. And maybe that would just force a dialogue between you and the solicitor or the agency. And I'm thinking maybe not think like Dauphin County, but other counties as well.
Yeah, I mean, I'll tell you, until the past maybe 5 years, I've really never talked to the solicitor at Children and Youth. I had great communications with the director and their supervisors and stuff, but I never really had a communication with the solicitors until recently, and that's been another, you know, you think you got everything perfect, you have everything going perfect, and then you discover some other area to work on, so.
Thank you. And Doctor, we're going to, as part of the ongoing education, doctors are going to get that training. It's like the policeman is your friend, the prosecutor is your friend. These guys, neither of them look like they tear people's throats open, except in a courtroom. And it is important that prosecutorial discretion have an opportunity to be exercised. And you know, we can't prosecute what we don't know about.
Let me just say, you know that doctors don't always love lawyers.
Right,
just
right.
for the record.
I hear you. And the example that you've used before, there's apparently lawyers, plaintiffs' negligence lawyers in particular, having inordinate ingenuity. I think some kind of federal derivative action have been brought against a couple of doctors, but which we may not be able to control with state law, but happily the federal courts have seen fit to throw them out. We may be speaking more. One of the issues that I have wrestled with in my head ever since getting this assignment is this business of who and how do we make liable for reporting. My understanding of the law is right now, if your colleague should decide to pull out a gun, shoot you dead, and stroll out of the room, none of us are obliged to be witnesses or to make a report to the police. Ultimately, if we're not forthcoming and cooperative, we can be held in front of a grand jury, but I don't think, the FBI purportedly has some kind of statute that if you lie to a G-man, you're breaking federal law. I think local police kind of expect to be lied to, and unless you do it in a way that obstructs the investigation or whatever, I'm not even sure that gives rise to prosecution, actually successful prosecutions, but certainly if you just stay mum, my understanding, no violation of the law. So that, especially making it, say, a felony of the first degree, to know about a child being raped and not report it is a substantial departure. Now, I'm not in favor of child rape, but it's, number one, tough proof issues, typically. I'm wondering if you are willing to sign on to a small working group. I think we need to engage about this a little bit to figure out something that actually works and gives people a clear understanding of their duties. I don't know if you have any further observations. I mean, how do we establish that somebody knows that this is happening, I guess, is one of the issues, certainly for folks like professionals who may see indications. Those indications should be brought forward, again, to law enforcement, it seems to me, but do you have any thoughts?
I mean, the biggest way you know typically is the child has told you that they told somebody. Okay. I just had a preliminary hearing last week for a grandmother who was whose one of her grandchildren was molesting 5 or 6 other of her grandchildren, and 2 of the grandchildren told her. Now, it doesn't fall under the mandated reporting statute, but the grandmother's behavior and response was so egregious that we filed endangering the welfare of children, where she told the child to shut up, she's a liar. Another time she came forward, she punished the child and grounded the child and took away privileges and those sorts of things. Those are the situations that I'm talking about. And if someone says that I told my teacher, or another case that recently came across my desk where a youth, I think a minister was being sought by a child to about something that was happening to her, and told him what was happening, and he didn't do anything with the information, let alone report it, didn't even tell the parents, and that child was abused again after that situation. It's going to be the child's word, so it's going to be like any other prosecution that we have. You're going to have one person's word against another, so the proof is going to be through the child's testimony and whether a jury believes the child, not only that the abuse occurred, but that they told somebody about it. But I would certainly be willing to work with anybody to help explore that issue. I know it's not an easy one, especially when you talk about raising the stakes, so to speak, with making it a felony one, or somehow finding some system. But I throw that out there to get the discussion going, because I really do think a misdemeanor of the 3rd degree is a slap on the wrist, and we need to encourage people to report. Children are a little bit different than if an adult was shot, because children many times are the abusers in their household, and they really have nowhere to turn. And when they find that person that they can turn to, that they think they can trust, and that person turns away and does nothing to help them, they're the ones that I'm thinking about when I'm talking about strengthening mandated reporting penalties.
I saw a variety of expressions go across your face, Mr.
No, I agree with what Sean said. I think, the structure, there's different structures that exist in the crimes code already in sort of similar type of situations where the penalties can be escalated depending on the type of evidence. I mean, if you're able to prove like a repeat intentional ignoring of this, it's akin to endangering the welfare of children, where if it's a course of conduct, it rises to the level of a felony rather than a misdemeanor. I mean, there's different ways that you could write the language to capture the extent of the failure by the person who didn't report.
You know, it's a felony of the third degree if someone knows that somebody is violating Megan's Law, and during the course of the investigation helps to cover up that. That's a felony of the third degree. So
An active cover, see, that's
Right.
you're usually looking for some other active element
Exactly.
as opposed to the passive. Yes, the site on that is,
Title 18, 3130, conduct related to sex offenders.
okay. Well, I would certainly solicit the, you folks, the DA's Association, in whatever form. I think this is going to require some artful crafting. I don't necessarily disagree with the examples you give, but it's a significant part of the responsibility of this task force.
Thank you both for coming today. I truly appreciate it. Sean, it's nice to see you're as passionate now as you were in the 80s when we first met. So I didn't think you'd be doing it this long, so I'm really happy to see that. I also appreciate that you're very solution-oriented, and I like that you pointed out the inconsistencies. I tried to write them all down, but I missed some, so I'm going to want to come back to you for that, because I do believe if we're speaking the same language, if we're using some of the same terminology, the issue of severe pain, or how do you define pain, has come up repeatedly. So to make it make sense, the issue of the simple assault, so, you know, a lot of those things, again, I tried to write it all down, but I'm sure I didn't get it. So I'll want to come back to you with that. The conversation about the regional training center, we should look into that. I don't know what it would cost. If they're looking for people to do it, I think it would serve Pennsylvania well to be part of that. And so, you know, from OCYS perspective, I think we absolutely need to be looking at that. You were talking about a lot about the cases that are reported and what's not reported to law enforcement. And philosophically, I've always debated, why wouldn't you report a crime to police? But the only place we don't report crimes to police is if it involves kids and their family members. So that, I've always struggled with that. Part of the reason, there's a couple reasons I struggle. One is because it's all about relationships. So if you change people, as people move on, you have different relationships, would they still work together? You know, when you talk about families, the doctor was right. You know, what you said, Sean, sitting down as a team and deciding what's in the best interest, that's a win. It's a win for the child, it's a win for the family. And that's great when you have those relationships. And I think we haven't gone that far in Pennsylvania because sometimes we don't have those relationships. But I want to explore that more. So, you know, I'd like to hear from even other district attorneys, maybe through the DA's Association. Both of you could talk to the other DAs, because I'm also wondering, for the referrals that you get from child welfare, do you have any idea across Pennsylvania how many actually get investigated? Do we have any idea about that?
I don't. I mean, I would like to think in Dauphin County, for each referral we get, to one degree or another, every case is investigated law enforcement-wise. But I really can't speak across the state.
And again, I don't see the prosecution as the win, like you said. The win is the group coming together and making a good decision for that child and family. That's fine. But I would like to know if law enforcement, are they investigating these the same way as they would other crimes before we make before we say, okay, well, child abuse should go to law enforcement for investigation. How are we doing today?
We have a requirement through our child abuse protocol that all those reports, the reporting comes through our district attorney's office. We have a person in our office, our child abuse coordinator, And our child abuse unit was originally funded through PCCD
I
grants.
remember that.
And our child abuse coordinator looks to find out which jurisdiction is the appropriate jurisdiction and then farms the case out to them. Or if it looks like multiple jurisdictions or a more complicated case, we may give it to our county detectives. But every report that comes through, we're referring to a police agency. And then if we don't hear back from them, we're calling them to find out what's the status of their investigation. Or if they're a little department, do you need us to give it to our county investigators to assist you here? Or can the state police assist you on those sorts of things?
Now, we heard that Philadelphia took 10 years to get this MOU. Do we know if other counties, or most other counties, do have an MOU?
I don't know. I do know that I think that we've gotten an increase in the number of abuse reports from DHS since this interagency protocol was done.
Did you
Because
specify which kind of cases? I'm sorry for butting in. Did you specify which kind of
There
cases?
is- it's in the protocol, which I wrote myself a note to give you a copy, and you can share it with the task force.
Okay, fabulous.
I'll email it to you today when I get back to the office.
Can't wait.
Maybe a little quick survey with the DAs might be in order at some point, just to get a feel for what they're doing. 67 counties, 67 DAs.
And to talk about
Thank you.
different languages, as part of the Children's Justice Act, CAPTA, we surveyed all 67 counties, mainly contacting the child welfare departments in each county, asking them to provide the protocols, their MDT protocols. And what I found interesting is I eagerly, when we got the results, went to look up Dauphin County's protocol, and they sent their MDT protocol, not their Joint Investigative Team protocol, which is what we were looking for, which was something totally different. Currently, the CJA task force subcommittee is looking at writing a model protocol for the state for multidisciplinary teams. So that's one of the things. And I think the communication, when one hand is actively working on a project such as that, and other areas don't know about it, I think that's where we need to publicize the work that's being done in the different areas.
Just a couple quick observations. One of which is that I have this very disquieting feeling from time to time that we're talking about the cases that we know. I wonder how many cases are happening that we don't know. Given some of the statistics I've heard earlier, that in fact if this 1 out of 4 or 1 out of 5 is in fact reality, I wonder how that translates into real numbers in the Commonwealth of Pennsylvania. I only say that to say, when we're done with this work, whatever resources we had, we need to logarithmically increase them, because I think what we're seeing is the tip of this problem. I don't think we're seeing the depth and breadth of this problem at all. And whatever recommendations we come up with, we are under a moral obligation to have the magnitude of the solutions match the magnitude of the problem. That's one observation. The second is, many of the suggestions that have been made make sense. I mean, teaching residents about child abuse, going into the state system of higher education, teaching the teachers about this subject, or the license plate opportunity. Those are obvious and brilliant and ought to be done. I'm concerned not about their brilliance, but about our ability to implement them. That simply to have them be memorialized in a report without some group addressing how it is that we're going to actually actualize these recommendations, I think we are directly tied to both recognition and implementation. And if the judge is correct that there needs to be impaneled a group of DAs to look at the felony consequences of X and Y, there may need to be some similar kind of group that's convened to look at some of the more practical opportunities that have been made available to us today. So I think at the end of the day, it is going to be resources. I think resources are going to be very important to both the findings and the outcomes of the report. And then thirdly, and there is no answer, but if people would do their jobs, it would make life a lot easier. Because a lot of the things that we're sitting here talking about, if people had a conscience and acted on what it is they see in front of their face, we wouldn't have to spend so much time on the regulatory side trying to get them to do behavior that largely is common sense.
Yep.
And if that is so, I think that the media program is going to be really important, that if Pennsylvania becomes known in this nation, maybe in the world, as a state that learned so much about the brutality of what it heard, that it decided to become a national leader in enforcement and resource promotion to get at this problem at a level of recognition and magnitude that we now have concluded that it deserves, then I think that this work will be memorialized in a very important way.
I can tell you the license plate idea, I've presented that a couple times over at least the past decade, and we still don't have it, so.
But that's my point.
But, yeah, so I definitely agree with you.
That's my point. We can't let that happen, not this time. There shouldn't have to be another time when you come back here and say something so obvious, that a high school kid would appreciate the brilliance and have no ability to implement that. That makes no sense.
I thank you for coming. I just have two brief and unrelated issues. The first is I want to echo for the record this issue of homeschooling. We had a case in Allegheny County recently, 11-year-old who was killed. Also, after 2 CYF removals returned, they decided to homeschool. I think this is one that there may need to be a special group on, because you could see how the system of higher education, CPS can't just tell them, oh, there's been a prior CPS report, now you need to have special regulations. And you can see right there, there's a communication that can't be had for confidentiality reasons. Should people not be allowed to homeschool or cyber school for that matter without any oversight if there's a certain situation that exists? But I think this is a much bigger issue. We're seeing it over and over. I would say of the kids that we see, I did 2 consults last week. One of the 2 was cyber schooled. The week before, my colleague did 4. One of hers was homeschooled. These are tremendously big numbers. Maybe it's just Western Pennsylvania, but we are seeing it in huge numbers, and the abuse is out of proportion to what it should be. So I think this is an issue that we really need to address. Probably will take a lot longer than this single task force. The other question is a very blunt and easy one. Are physicians mandated reporters to police when there's child abuse, suspected child abuse?
I think.
So here's the scenario that occurs
and
over
this,
and over.
I get into this with solicitors for hospitals on this one, as to whether that winds up taking you into, and again, all these things are in, that's why I have this book tabbed out. They're all in different sections here.
You should have them on an iPad. It would be less weight.
The reason I'm asking is obviously a practical matter, is that if, as a physician, I want to report to CYF, I honestly don't want to report to the police. It's a whole different issue of whether you prosecute. And my job, I feel, as a mandated reporter, to report child abuse to Childline. But we have been told that if we don't report to police independently, it is a crime. And I don't understand that. And so I'm asking, is that in the law?
The thing in the law is the same section that requires the report of firearm wounds and those sorts of things. That's where you find 5106 in Title 18 of the Crimes Code deals with the failure to report injuries. And it depends on how you define injury as to whether that's specifically reported. But what I want to get across is a more important thing, is the misconception that just because you're reporting to law enforcement, you're doing something wrong, that the police are going to come in and it's going to be all draconian and we're going to be filing criminal charges and we're going to be hauling parents away and those sorts of things. If it's done right, that's not what's happening. What you're doing when law enforcement becomes involved is you are bringing all of the resources that law enforcement has to investigate a case, which is much greater resources than you'll ever find in the Child Protective Services arena to thoroughly investigate a case. You asked about, Mr. Strickland, you asked about, under-reporting and those sorts of things. I had a case where a mother complained to the police that a man that was a friend of her, he was an adult, her son was nine years old. He had set up a MySpace account for her son, and she was upset about that, and she went to her local police department complaining about it. It took that police officer that police detective, the forethought to look into that, not just as another mother complaining about something. And when he started looking at that, he put 2 and 2 with another investigation that had been around a year ago, a year previously. That investigation led to, at this point in time, 20 kids over 2 decades that were abused by this man, sexually abused. This guy was doing all sorts of things. But it took the police being able to get search warrants to go into the home and those sorts of things. We have so many tools that are not available to the Child Protective Services. And if they work together, I can say to the children and youth caseworker, you guys take the lead on this, okay? Maybe you should be the ones talking to the parents. We'll take the back seat, but at least we're making that decision together. And that's where I think the team approach, rather than picturing one side's going to do this and one side's going to do that, if we picture that it's a team approach and all the sides are out for the same thing, which I would think and hope that the physician is out for too, that the right outcome that makes sure the child's going to be safe.
I'm obviously not saying we don't want, but I think that the idea that a mandated reporter is required to report to more than one person.
Oh, no, I think you should only report one place.
To make a decision about whether it reaches bodily force is a decision that shouldn't be made by the mandated reporter. I think that I don't know if it's a change in the law. CPS, absolutely. I think every case at least you should know about, and then you can decide if it's a crime or not. But I don't think it should be on the mandated reporter that if you don't report that whatever has been defined as bodily harm, now the mandated reporter is responsible because only a call to CYF was made. And I don't think that was the intent of the law, but there are multiple counties where that's the way it's been interpreted.
Yeah,
the physician has a requirement, or else the mandated reporter, whether or not it's the physician, the mandated reporter is required to make both phone calls. And I think that that's a misinterpretation.
I think you should have one place to call, and that should be Childline.
So I don't know if that's a change in the law that needs to happen or not. I mean, it sounds like it's in the law that if you know of a crime with a bodily weapon, and
whatever.
Well, if you have a gunshot wound, you have to report.
Right, but that's a different issue than a child with a bruise, which someone may define as bodily harm, somebody else may not. CYF may need to get law enforcement involved, but I don't think it's the mandated reporter's role to make 2 different phone calls.
Well, that's why we have 2 physicians on this panel, so that particular point of view we can be sure is going to be heard as we redraft.
But I absolutely agree with everything. I absolutely agree that we should have a multidisciplinary team. The question is how it comes together.
I think if we make it difficult for somebody to report, it makes it that much harder to have reports made.
And Ms. Rumper.
Well, I just want to comment, I think, mostly on Bill's question about how many cases are never reported. Most research indicates that of sexual assaults, it's almost 90%, and I think that if you'll look, you'll find that's pretty consistent. Now, I don't know where the differentiation is right now. I don't have anything between children and adults, but it's pretty consistent. Almost 90% of sexual assaults are never reported. And part of that is systems have failed us. People don't believe the children. I think we've heard examples of that already. And it is until particularly children know that it's safe to tell and they're going to be protected and people are going to believe them, we're going to consistently have people not telling. And, of course, the stigma. We have to. And you keep talking about a public awareness campaign. Again, there's that stigma attached. Even a small child knows something's wrong, it wasn't right. And so until we get rid of the stigma through some sort of education and training, we're going to consistently hear that 90% are not reporting.
Yeah, this was a study from 2000. It says 65% of social workers, 53% of physicians, 58% of physician assistants were not reporting all cases of sexual abuse, suspected child abuse, and a survey of 197 teachers given 2 hypothetical cases. The first hypothetical, the teachers were asked if they would make a report when a student tells them that a stepfather has been touching their genitals. The second hypothetical was teachers were asked if they would make a report when a student tells them that another teacher was touching their genitals. Only 26% of the teachers reported in that first instance, and only 11% said they would report in the second instance. And I think that brings it all back to the education piece.
Exactly.
Thank you very much. I could not imagine prosecutors being better represented, we thank you for your time and effort.
Thank you.
And I got us off to a late start, and we have grown only later since then. Our next presenter, who was scheduled for noon time, is the Department of State Bureau of Professional and Occupational Affairs. And Commissioner True, I see that you are with us, but you have delegated the job to your general counsel, despite the fact we have two doctors who take a dim view of lawyers. I'm sure he's
this kind of lawyer.
It's just
that's
a
right.
generalization, not every lawyer,
Yeah.
just most.
Yeah.
Well, thank you, Judge Heckler. I am cognizant of the fact that I'm the last panelist, the solo panelist, and scheduled to conclude at 12:45. But if I can, I don't know if Sean's still around. Well, if I can start with just a brief bit of levity. I remember in late August of 1986, when I walked through the doors of what was then known as Delaware Law School of Widener University, probably somewhat starry-eyed, maybe even glassy-eyed, and saw a fellow in front of me who looked just as lost as I did and said, "Hi, I'm Travis." He said, "Hi, I'm Sean McCormick. Nice to meet you." And Sean went off to the Dauphin County DA's office. I went off to the Navy JAG Corps. And when I was on active duty, they had one pretty cool seminar that was an out-service training that they would send folks to, and that was the National District Attorneys Association Child Abuse Investigation 2-week course. I went to that, and as odd as it sounds, became hooked immediately, and have been passionate for kids since then. And in 1993, when I was coming off active duty, I called my friend Sean and said, "Hey, you know anybody that's hiring?" And he said, "Well, the Dauphin County DA's office." So I actually spent a year there with Sean before I went over to the Cumberland County DA's office and did what he did over there. And actually, I don't know if you recall, but had the pleasure of having Dr. Christian as one of my expert witnesses. And it's pretty cool when you can look at the jury and say, my expert wrote the book. No, literally, my expert wrote the book on child abuse investigation and prosecution. But that's not why I'm here today. I do want to start by thanking the members of the General Assembly, the House and the Senate, as well as the Governor, for taking this matter seriously and establishing a task force to look into this. And I thank each one of you individually for the amount of work and dedication that you put into this, frankly, in my opinion, most worthy of noble causes. Within the Bureau of Professional and Occupational Affairs, we have some involvement with child abuse investigations. Frankly, ours is somewhat limited, and that is to the area of mandatory reporting, which you have been talking about. And I'd like to just go over a little bit of background. Some of you may be familiar with the Bureau of Professional Occupational Affairs. Some of you probably aren't. And in fact, if you're not a licensed professional, you've probably never heard of us and are wondering, why is the Department of State here today? The Bureau of Professional and Occupational Affairs was established by statute in 1963. It is the state agency that administers the licensed professions and occupations in the Commonwealth. Right now, there are 29 boards and commissions. Of those, 16 are health-related. And when I say the licensed professionals and occupations, we administer and oversee the various boards and commissions, such as the State Board of Medicine, the State Board of Osteopathic Medicine, the State Board of Nursing, occupational therapists, physical therapists, all the individuals like that. Right now, we have 207 various license types, and we license 2.5 million individuals. Of those, 250,000 of those licensees are nurses, and there are approximately 270,000 licensees in the other health care professions. That is important because we are, to a certain extent, the teeth that Sean indicated was missing. The Child Protective Service statute that you all have been talking about that lists individuals or classifications of individuals who are mandated reporters includes pretty much everybody that we license on the health side. The doctors, the nurses, the physical therapists, occupational therapists, funeral directors. I mean, when you go through the list, they are licensed professionals. And even though, on the one hand, it is a criminal offense and there are criminal penalties for those that fail to live up to their statutory obligation to report cases of suspected child abuse, each one of the health-related boards has established by regulation the requirement that those licensees report their cases of suspected child abuse. So if they do not, it is more than simply a criminal offense, or, I say simply a criminal offense, more than simply a misdemeanor of the third degree. It is also a violation of their practice regulations. That is important because the ultimate penalty that we can impose upon a licensee who fails to carry out their Practice Act requirements or regulations is suspension or revocation of their license. And if you're talking about the professionals who that's how they make their living, being able to practice their profession is essential. So we do get involved in it in that area and add a little bit of backup to the criminal statute. I can tell you that I've canvassed our folks, and within the department, we have each of the various boards are autonomous, independent bodies. They're made up of individuals, members of their profession, as well as each board has public members. Each of the members are appointed by the governor, but approved, confirmed by the Senate, and they are charged with administering the various practice acts. Each of the boards are creatures of statute that operate under a statute that basically sets up the board and then sets forth the powers and duties and responsibilities of the various boards. And typically within the acts also are what are called the standards of care within the profession, the minimal requirements that members of the profession must adhere to. Within the Bureau, we've got the legal office, which I head and serve as counsel to the Commissioner. Within the office, we've got our prosecution division, which goes after, much like the district attorney would do for criminal matters, we prosecute the licensees for violating their acts. And we also have a division that's called the counsel division, which serves as board counsel or general counsel for the various boards and commissions. And I've canvassed my folks in both the prosecution side and the counsel side, and quite frankly, none of them can recall a prosecution that we brought, the basis for which was failing to report a mandated report. Now, does that mean that there are no mandated reporters who are not living up to their obligation? No, it means we're not hearing about it. The way we would hear about it is if someone would complain, and the someone could be the victim of child abuse. It could be someone else in a healthcare facility who worked with a doctor or a nurse or some other mandated reporter who knew that they didn't. They could report that to us. It could also be, we would come across something, a newspaper article where something came out that an individual who was a mandated reporter failed to file a report, and then we could start an investigation. One of the things that would help us to do our job is if there were a requirement upon the licensees to notify us if they were charged with failing to file a mandatory report. Right now, the doctors on the panel, I'm sure, are familiar with the MCARE Act, the Medical Care and Reduction of Errors Act. Under that, every physician in the Commonwealth is required to notify the board, the State Board of Medicine or the State Board of Osteopathic Medicine, whichever is the licensing agency, anytime they are sued civilly. Now, that doesn't mean that we will always proceed to a licensure disciplinary action against a physician. It just means that we get wind of it, and we now know to monitor it and to watch to see if there's something there. If licensees were required to notify us, if they were, whatever the threshold would be, charged with failing to file a mandatory report, or convicted of failing to file a mandatory report, that would certainly get them on our radar screen, and we could then do the appropriate licensure action if any were to follow. One of the other issues that has come up, and frankly I'm familiar with the big incident that gave rise to the existence of this task force, and when that story broke publicly, one of the things that we did within the department or within the Bureau is, sit down with the chiefs of my divisions and said, okay, let's look at our mandatory reporting requirements and what is it that we do. And right now, actually, this is an area where I don't think we're really that far behind the 8 ball. As I said, all of our health-related boards have within their regulatory framework obligations to report cases of suspected child abuse. I won't go through and belabor all the problems inherent in that you've heard from all the panelists, not just today, but on your previous sessions also, with the definitions, what constitutes child abuse, the requirement for severe pain, the injury, and all that. All of our regulations track the Child Protective Services Act. So if there were any changes to that, we could follow through, and well, actually, I'm not even sure any would be necessary. Some of our regulations do set forth the 4 subcategory definitions within the Child Protective Services Act that talk about what constitutes child abuse, so we would do that. The one thing that we are doing is not all of the regulations across the various health-related boards are identical. They're all very similar. We are going through and actually trying to put through regulatory packages that would make them all consistent. I think in spirit they all require the same thing right now, but they're just not all identical, and it makes sense that they would be because they all do require the same thing. So we're going to look to try and streamline that. Unfortunately, in order to do that, we have to go through the regulatory review process, and it's not a 1-week evolution. It's more like an 18-month evolution if everything goes well. But we are in the process of doing that. One of the issues, if I could, also, I believe all of our licensing boards, particularly in the health-related field, and I think all of them now, do have some kind of continuing education requirement. One of the things that we actually are looking at is, should the boards require continuing education in this specific area, recognizing signs of child abuse, and then the mandatory reporting requirements. That could be dealt with essentially 2 ways. One, statutorily. Certainly, the General Assembly could pass an all-encompassing statute or amendment to an existing statute that says all mandated reporters who are licensed professionals must, as part of their continuing licensure, take whatever the ultimate determination would be. Every biennium, take 1 credit hour, 2 credit hours, whatever, in mandatory reporting and recognizing child abuse. Or it could also be done on a board-by-board basis with each board through regulation, saying we think this is an important issue. The regulatory arena is one of the things that we are looking at and are going to be addressing with the various boards to see if it's something that the boards would want to pursue. We have also, we're working with the boards to just reinforce the mandatory reporting requirements amongst their licensed community. Frankly, most of the licensed professionals understand the requirement to file the mandatory reports. And one of the issues that was brought up with the previous panel was the notion of failing to report. What happens when you fail to report, and then what happens to those that file false reports? And that, frankly, is an area where I think the law actually does provide significant coverage. The 6311 of the Child Protective Service Act deals with persons required to report suspected child abuse, and these are the mandatory reporters. And it goes through and enumerates all the different individuals who have to report. But then, right after that is the section that Sean was alluding to. Section 6312 says, in addition to those persons and officials required to report suspected child abuse, any person may make such a report if that person has reasonable cause to suspect that a child is an abused child, which, you know, Mr. Strickland goes pretty much exactly to what you were saying and what the commissioner was saying to me when we were listening. It's one of those instances where, I mean, just do the right thing. And this is one of those instances where do the right thing because Section 6318 says any person, whether required or not, cooperating with an investigation who files a report is immune from civil and criminal liability that might otherwise result by reason of these actions. And it has, Sean mentioned, it has the good faith requirement in there. But actually, the General Assembly went a step further and said in subsection B, for the purpose of any civil or criminal proceeding, the good faith of a person required to report pursuant to 6311 and of any person required to make a referral to law enforcement shall be presumed. So the burden shifts to the people bringing the suit to prove that a report was not made in good faith. Now, are there instances where you would have individuals using this as a tool to gain an upper hand in a custody battle or something like that? Of course. But when they're called on the carpet to give a reason, well, why did you come forward and file a report of suspected child abuse? And, keep in mind, all this does is require certain individuals who we believe are going to have specific knowledge of what's going on that typically happens behind closed doors. They have to file a report. It doesn't necessarily follow that, as Sean was alluding to, it doesn't necessarily follow that there is going to be a criminal prosecution, a professional licensure action. All it does is get people who know what to look for involved and look. And it takes that child who, talk about preaching to the choir. This is probably the ultimate example of that. But, you get a child who is, first of all, just almost by definition of who and what they are, reluctant to say anything anyway, and then put on top of that the embarrassment, the fear, the pain, everything that's heaped on top of that child, and then the threats of, what's going to happen if daddy's the abuser? Well, daddy's probably also paying the rent, providing the food, doing all the other stuff, and boy, I'll tell you, most of the other caregiver who we like to think is going to be protective is dependent on the abuser also. So we need a way to get that child to talk to somebody. That's what the mandatory reporting does. And how do we enforce the mandatory reporting? Well, Sean alluded to that. It's a criminal penalty, and also that's where we come in. And I think when I started by saying we don't have any instances where we pursued a prosecution, the basis for which was failure to file a mandatory report, maybe I am overly optimistic in this one area, but I actually believe that's because most of the licensed professionals that we would deal with understand, number one, they have to do it, number two, they're protected if they do it, and number three, if they don't do it, they're in trouble, not with a misdemeanor 3, but with potential action against their professional license. And that is, particularly for the doctors, the psychologists, the nurses. I mean, as I said, this is their livelihood on the line. Without their license, they can't practice. Without their practice, they can't eat. So there is that avenue behind them. Because I am an old trial lawyer, and because I've been given a soapbox, I also have to, follow on with some issues about not just educating the mandatory reporters, but, I think, Mr. Strickland, this is another one of your observations. We need to educate everybody. We need to educate, all the prosecutors, all the police officers, all the child protective service people, but we also need to educate, defense lawyers. We need to educate judges. We need to educate the jury pool. because, this is some horrific stuff we're talking about. And in order for John Q. Public to accept that this stuff happens, John Q. Public has to recognize that his child is vulnerable. And nobody wants to do that. And too often, take the prosecutor out of court, but you can't take. Too often, we see the system and the victim being attacked. We need to educate the public that this stuff really does happen. And we need to educate the public that when you hear ridiculous defense lawyers say outrageous comments like, well, we were just teaching the child how to do proper hygiene, that's just unacceptable. I mean, that, I don't even know how to address stuff like that. And that, that's one of those that is an embarrassment to me as a member of the bar to see my, brothers and sisters licensed to practice out there, doing things like that. I better stop before I get too carried away. And I'm happy to answer any questions about how the Bureau gets involved in this.
Yeah, I'm always ready with a question. Hi, nice to see you again after all these years. So a couple of things, and I think I may have said this for the record, but I'll say it one more time. I think mandated reporters do appreciate the immunity that we have when we report in good faith. But there are many physicians who get kind of caught up, not because they were the mandated reporters, but in part because they've been cooperating with investigations. And I think that that's probably a simple fix to the laws that would also kind of provide protection to those who cooperate with investigations in good faith. On the flip side, I've seen a number of physicians who are sued in civil court in malpractice cases for failing to identify children who are victims of abuse, who then are returned to situations where they are re-abused and then then later identified. And it seemed to me when you were talking about kind of tracking and under MCARE where physicians have to identify all civil whatever complaints or lawsuits, that would be a way to actually identify some of the cases where physicians have been identified as failing to report. On the other hand, I do want to say for the record as well, in many of those cases, the lawsuit doesn't mean that the physician was negligent, because these cases are very difficult to identify when people lie to you and the children present initially with nonspecific symptoms. But that's just one mechanism I thought of to track those cases.
Absolutely, and actually I'm glad that you brought that up, because one of the things I skipped over that would help not just us for purposes of tracking the physicians or the mandatory reporters, but also what I think helps significantly on the actual going after the abuser's side is record maintenance. If all of the individuals, and I understand the need for confidentiality, because these reports are very sensitive, and it is the kind of allegation that once it's made, I mean, it's bad whether it's founded or unfounded, substantiated or unsubstantiated, so for those that are unfounded, unsubstantiated, we do need to maintain a high level of confidentiality. However, it is essential, in my opinion, that agencies charged with getting these records have an obligation to maintain them for a significant period of time, because one of the things that prosecutors can use to go after abusers is patterns of conduct. And oftentimes, and again, this is not the BPOA person in me, this is the old child abuse prosecutor in me, to say that a child has to suffer serious pain or significant pain, that's ridiculous. You can cause just as much harm to a child by repeated lower level abuse that goes on over time. And that's something that if records were maintained and cataloged, a child protective service person could look at that and say, this is the 17th report we've gotten on this. Wow. So that's another area that I would suggest that the task force look at, just the requirement to maintain records. And I believe, Dr. Christian specifically, to get to you on the immunity from liability issue, I mean, as I read it, I think the immunity statute is written broadly enough that it does encompass not just reporting, but there's also immunity given for assisting in an investigation, if done in good faith. And maybe it's just a matter of, focusing on that and educating more of the reporters that provision does exist in the law. Because I agree, much of the emphasis is on you must report, you must report, you must report, and we forget about the second section that deals with and assist in investigations and things like that. And the other, Dr. Berger, you had mentioned about the reporters only having to make one report, which makes a lot of sense to me. The other issue that, in the Child Protective Service law, if you're in an institution, you as the individual who has hands-on contact can report to your institutional head or the person designated by the agency, and then that person's got the responsibility. I mean, I can understand why an institution would want that in place so they know what's going on, but, from the, prosecutor who gets the information, I'd like it coming from the lowest level hands-on person possible. So, maybe that's something in the reporting statute that needs to be looked at also.
We're aware of that.
Doctors just don't like to get sued, even if they've got a defense. And who can blame them?
Yeah, that's a general statement I agree with.
Travis, nice seeing you again. Thank you for what you do, and thanks for bringing the soapbox. I appreciate it. Keep building on top of that. We need you to keep working in this arena too. Going in the reverse direction, and that is if a report should be received by one of your boards, your various boards, on suspected child abuse, do you have a mechanism that requires the information to flow back the other way?
We do, actually. Most of our reports of suspected child abuse would come to us not from a mandated reporter who suspects child abuse. It would come as an allegation against a licensee. And right now, the way it stands is the way we get information is if a complaint is filed with the Bureau, and that can be, it can come in from a various, the actual victim of abuse, a parent, a friend, coworker, competitor licensee. Once it comes into us, we then open an investigation. And this is not limited to child abuse. This is any kind of deviation from standard of practice or standard of care type issue with any of our licensees. If during the course of an investigation we uncover activity that we believe rises to the level of criminal conduct, we have the ability to share that information with law enforcement agencies. Most of our information is statutorily made confidential by statute, so we don't share it. One of the exceptions to that is we can share with law enforcement agencies. So if we had a report of suspected child abuse being perpetrated by one of our licensees, that is something that, obviously going up through the appropriate chains, but we would refer out to the appropriate law enforcement agencies for them to look at. That doesn't mean that our investigation is put on hold. Oftentimes it does because, quite frankly, we recognize that in many instances the criminal investigation, number one, can move faster than we can, and number two is predominant. We don't want to do anything to mess that up. So if we are requested by the law enforcement agencies to kind of stand down pending their resolution, we would generally do that. There are some cases where we wouldn't, but that would be after internal discussions. For the most part, we would stand down and wait.
Just to clarify, when you say you may refer to law enforcement, so two questions. One, is it may or shall?
It is not shall. The statute is we are permitted to. I can tell you that, as I said, I'm a former prosecutor. Our basic understanding right now is we do. Now, there are some, and frankly, there are some that we would refer out, and, the cognizant district attorney's office might look at it, and it may not meet their threshold or their standards, or they may not believe that there's sufficient proof for them to go forward, and that's fine.
Is CYS considered part of law enforcement for that reporting purpose, or just truly law enforcement?
It's just truly law enforcement, but once law enforcement gets it, that's who CYS would be reporting it to, and as Sean said, most of them work pretty well together anyway, so I think ultimately we'd end up getting back there.
Go ahead.
And the other is, keep in mind that we would only be, in that scenario, we would only be dealing with situations where the alleged perpetrator is one of our licensees.
The professional numbering system, I presume that all of your licensees have a designated number of some sort. Is it a number that is consistently applied through the different professions, or is it a particular tag that goes along with pharmacists, or, in other words, if I...
A license number?
Yes.
It's by board, by each individual board. Like our bar number,
right.
A pharmacist would have a number associated with their license. A doctor would have a number associated with their license.
Are there any numerals or letters or digits or anything that identifies one particular licensee to a particular under a board, or are they just digits, numbers, numerical numbers?
There are. Internally, we can tell. I'm not sure if the numbers are available on our public website. If you went, you can go into our public website and look up any licensed individual, and you can put it in by license number or by name. And if that name is associated with one of our licensees, it'll pop up and it'll tell you by what board they are licensed.
And I'm just thinking big picture, if we're talking about how do we integrate data and with working with statewide reporting systems, Childline, that sort of thing, there should be a way that we uniform all this so that we can, when a report comes in, all this information is disseminated to the appropriate person. So if it is a licensed person, we know that right away. It goes to you right away.
Yeah, and frankly, we would not need to know beforehand the actual board that issued the license, as long as it's a licensee. So you wouldn't have to tell us, we've got this person licensed by the State Board of Medicine who failed to report. If you told us we've got, John Smith, that they're a licensed professional, we can figure out what board it is as soon as it pops into us.
What's the general requirement for your licensees to provide that data that they're being investigated? Is it investigated or convicted, or what's the standard?
Right now, there's nothing. I think there may be a few boards that are required to report convictions. There are some boards, actually I think the majority of the boards, that on their biennial renewal are required to check yes or no if they've been convicted since the last renewal period. There's generally nothing that says when you get arrested, when you get charged, when you get convicted, you must immediately notify us.
How do you know that you're, like, if I'm a physician and I've been, I'm being investigated for abusing my patients, for example, how do you know that you're going to find out about it, or do you not find out about a lot of them?
You as a physician?
Well, yeah, like if someone who's licensed is being investigated for child abuse, is there some mechanism by which the licensing board automatically knows about these?
No.
So do you think you know about 5%, 50%, 90%?
Right now, if one of our licensees is being investigated for suspected child abuse, the only way we would find out about it is if we read a newspaper report about it, or if one of the investigative agencies, there are a number of former prosecutors in my office who have developed, some pretty good contacts throughout the state, and oftentimes somebody will call us and give us a heads up. But that is one where if we had mandatory self-reporting, that would be very nice.
If we were to recommend that, I personally agree with you. What's a reasonable period of time that someone should self-report, and what's the mechanism to start that? Is it becoming aware that you're investigated? Is it charged? Is it indicated abuse by the CYS agency?
I would say at a minimum, upon conviction, you should, and in that case, to me, a reasonable amount of time is immediately.
But Why would you make the person do that? Why wouldn't you have a mechanism by which?
Well, or we could also do that, that's right. I mean, if it could be, have the district attorneys automatically notify us.
That's why I was asking the questions about the ID, because what happens is often the perpetrator receives a target letter, in general terminology. You are the subject to report, and the subject defines parents, child, and the perpetrator. And so that could be the mechanism by, once that child line number hits, it seems to me that's very easy if we could figure out how to have systems talk.
Yes. And I should say, one of the things that we actually started after I came into the office was we are working with the information folks to coordinate with JNet, the system that sends out notifications whenever certain triggering events happen. It's one of those, we're reluctant to request that we be notified of every arrest for every licensee, because we'd just be inundated. But we're working on coming up with the parameters so when certain things happen to certain individuals, we would automatically get a notice, and then we could do whatever it is we could do with that information.
Do you folks oversee the licensure of teachers, or is that the Department of
We do
Ed?
not. That's the Department of Education.
Okay. Thank you.
But I think where you're going with that, Judge, is right on. Just because they're not under his jurisdiction doesn't mean they should be exempted. Whatever we come up with by way of a solution here, we ought to generalize it and take it to our colleagues in the other agencies, particularly education. And as sad as it is, economic consequences change behavior.
Absolutely.
If you make the traffic ticket $500, people slow down. If it's $35, they'll take the risk. And I think that what you've touched on is a very, very important point and needs to be emphasized in whatever education process we're using to bring these professionals online. I think it makes sense to take what you're implying and suggesting and make that a part of the professional educational licensing process so that people are told and reminded that there are significant implications for this behavior, that this is not a misdemeanor, this is a big deal, and you run the serious risk of losing your license. That keeps people's attention. And from time to time, a periodic notification by way of a bulletin or a notice, just to keep everybody aware of this, would not hurt either. Relatively low cost to do.
I believe most of our boards send out periodic newsletters to their licensees, and after the Sandusky matter became public, I believe many of them actually did include a blurb in there, many of those that are mandatory reporters, reminding them of, hey, you're a mandatory reporter, and these are the things that must be reported, and there are ramifications if you don't.
Well, I think it's important that the psychology of the notice match the opportunity. Meaning, not a footnote on the 5th page at the bottom of the bulletin, but that this thing is elevated to the level that it deserves. And because the public, of course, 3 years from now, won't even remember who Sandusky was, but we have an obligation to not let anybody forget, particularly these people who have an opportunity to have prevented some of this stuff.
And, if I could on that, I was remiss in the beginning because I didn't give more due accolades to my commissioner, Katie True. Some of you know Katie from several of her previous lives. She was a former state representative, but before that got involved in some activities involving kids. And it's absolutely a privilege and an honor to work for her, because I've never met someone who's a more ardent advocate for children across the spectrum. As I said, right now, the Bureau's role in this is fairly limited to, monitoring the licensees that are required to mandatorily report. But, if you walk into Katie's office today, behind her desk, she's got I don't know how big it is, poster of just a picture of a young boy who the system failed. And that child lost his life because he was abused and the system failed. So I hear what you're saying, and I can assure you that our Bureau is led by a woman, a commissioner, who absolutely takes this seriously.
Terrific. Thank you.
Hi, Travis. I remember you from your ADA days.
A while ago.
And you just said some very kind but true words about Commissioner True, who I also recall back in the mid-'90s when there was a push to change CPS law. At that time was one of the forces behind that. And we had a case out of Blair County, and we relied heavily on her assistance to address a situation where, unfortunately, Children and Youth Services allowed a child to go back into a home and the child was murdered. In any event, my question is really simple. Is there a website that lists which licenses your agency oversees?
Yes, if you go to the Department of State's website, on the, I think it's the left side, there's a drop-down click for just licensing, and I believe that takes you to another. Then you can break it down from the health-related and business-related boards, and you can find it on there. I mean, I can shoot you something, too, that just lists them all.
My point to ask you that is simply because I know the mandated reporting statute is very specific about examples of types of mandated reporters, but that your agency actually oversees other individuals as well, who may also fall into a more general description and aren't specifically set forth, but seeing them listed somewhere might be helpful to a law enforcement agency or a district attorney's office to look through those. I had a case not that long ago where I had a massage therapist who was abusing one of his patients, and there was a big debate about whether or not that person fell under the licensing statute. So my point in raising that is simply to say we should be aware not just of what is specifically listed, but also generally what's included in that, and follow through with looking at the website.
Absolutely.
Thank you.
And that's a lesson on why you always have to be careful and be nice to people you meet along the way.
Doctor?
I don't have any comments. Thank you, though, for coming.
My guess is the initials of the young boy behind your desk were MF. And that was a case which Berks and Lancaster tragically shared. Just one comment, and it's a very quick one. And that is that with regard to continuing education requirements for mandatory reporters, I think it ought to be by legislation as opposed to regulation.
I'm going to pass.
Fair enough. Well, thank you very much. And our next proceedings will be in Pittsburgh on the 31st of this month. We'll see many of you there.
Okay. So impressed.